Hi, Laura back again, and this time I'm here to discuss a key contract law principle, the battle of the forms. This is something that appears in numerous levels of the SIPS qualifications, and it relates to English law. The battle of the forms is a situation where both the buyer and the seller attempt to establish their terms as the basis of the contract. So essentially, both parties want their contract to be the one that governs that contract. So why do we want our contract to be the basis of the agreement? Well, because our contracts manage our risk. They're more likely to cover us and put the risk onto the supplier. Therefore, we want our contract terms, the one that protects us the best, to be the one that governs the overall agreement. Let's talk about the analysis of Battle of the Forms. Any analysis of the Battle of the Forms has to look at the documents that pass and what their legal status is. So that would be invitations to treat, offers, counter-offers, and unconditional acceptance. The last shot principle. So there is a general rule or principle in the Battle of the Forms that normally the party that fires the last shot, which means sends the last document, will win the Battle of the Forms, since it's likely to be a counter-offer, and a counter-offer destroys any previous offers and is in itself a new offer. Therefore, this puts the supplier in a more advantageous position because they're the ones that usually send the last shot, i.e. the delivery note. That doesn't mean that the supplier will always win, and we can find ways to limit this. Butler machine tool versus Excello. So this was the precedent case that set the rule for Battle of the Forms in the UK. Butler quoted a price for a machine tool of £80,000. The terms included a clause which stated that its terms would prevail over any terms introduced by the buyer. So they wanted to ensure that their terms was the one that prevailed. You can't do this legally, by the way. These terms included a price variation clause. It stated that prices may vary. Excello then ordered the machine, and its order stated that the contract was to be on Excello standard terms on the back of the order. There was no price variation clauses in these terms whatsoever. So Excello sent a purchase order with their own terms and conditions on the back. The order form that Excello sent contained an acceptance tear-off slip, which Butler signed and returned. Costs increased before delivery, and Butler invoiced for an additional £3,000. Excello refused to pay this, and it went to court. So who did the judge hold for? Who won the Battle of the Forms? Well, if you said Excello, you would have been correct. Butler sent that detailed quotation, which was an offer. However, it wasn't accepted by Excello. When they sent their purchase order with their own terms, this was a counter-offer that destroyed that original one. Butler signed and returned that tear-off slip, and so they accepted unconditionally Excello's terms, which meant no price variation clause. So Excello won the Battle of the Forms, and they didn't have to pay the additional £3,000. So how do we go about then avoiding the Battle of the Forms? Well, there are numerous ways. However, the three that tend to work the best I've included in this video. A properly conducted tendering exercise avoids the Battle of the Forms because when you send out your tender documents, it has your terms and conditions on the back. Therefore, when a supplier is submitting their bid, they're making an offer on your terms. A framework agreement is agreeing the terms and conditions up front, so anything that passes afterwards is pointless. And finally, stamping the delivery note accepted as per our terms and conditions is also an effective way of firing that last shot. I really hope you found this useful. Thanks so much for listening. Please subscribe, and I'll catch you back on the next one soon. Bye.